The American Old West had laws, but not the kind you learn about in school. These were laws written by desperate men in desperate places. Laws that would land you in prison today. Laws that protected murderers, punished the innocent, and made cruelty perfectly legal. Some of these laws were printed in official territorial statutes. Others were enforced by judges who had never read a single page of legal text. And a few were so disturbing that later governments quietly erased them from the record, pretending they never existed. What you're about to hear are 15 real laws from the American frontier. Laws that govern life, death, marriage, property, and punishment in ways that will make you question everything you thought you knew about justice. These are not legends. These are not exaggerations. These are the actual rules that shaped the Old West. And once you understand them, you'll realize the frontier was far stranger and far darker than any Western film ever dared to show. Before we begin, you need to understand something important. The Old West was not a single place with a single legal system. It was a patchwork of territories, each with its own rules, its own judges, and its own definition of right and wrong. What was legal in Texas might be punishable by death in California. What was forbidden in Kansas might be encouraged in Montana. There was no Supreme Court watching over these territories, no federal oversight, no appeals process that actually worked. The laws you're about to hear were real. They were enforced, and they shaped the lives of millions of people who had no choice but to obey them. Some of these laws lasted for decades. Others were quietly repealed when statehood arrived, and outsiders started asking uncomfortable questions. But for the men, women, and children who lived under them, these laws were absolute. They were the difference between freedom and prison, between life and death. Let's begin in the modern world. Killing someone for stealing your property will result in a murder charge. In the Old West, it was not only legal, it was expected. Multiple territories, including Texas, Montana, and portions of the Arizona Territory, had statutes that explicitly permitted property owners to kill horse thieves without trial, without warning, and without legal consequence. The logic was brutally simple. On the frontier, a horse was not merely transportation. It was survival. A man without a horse in the desert or plains could die of thirst, starvation, or exposure within days. Stealing a horse was therefore considered equivalent to attempted murder, and the punishment matched. One Texas statute from the territorial period stated that any person caught in the act of stealing livestock could be dispatched by any means necessary by the owner or any witness to the crime. The word dispatched was deliberately vague. It meant whatever the property owner decided it meant. There are documented cases of men being shot in the back while riding away on stolen horses. The shooters were never charged. In several instances, they were publicly thanked by local authorities for maintaining order. One rancher in the Pecos region reportedly killed 3 separate horse thieves over a span of 5 years. Each time, the local sheriff simply recorded the deaths as justified homicide and closed the case within hours. No investigation, no witnesses called, no questions asked. The horse thief law remained on the books in some areas until well after statehood. It was only removed when Eastern lawyers began pointing out that it violated basic principles of due process. But for decades, it was the law of the land, and countless men died because of it. Today, the idea that a human being could be legally classified as property seems unthinkable. But in certain Western territories, married women had fewer legal rights than livestock. Under the doctrine of coverture, which was enforced throughout most of the frontier, a woman's legal identity was completely absorbed by her husband upon marriage. She could not own property. She could not sign contracts. She could not sue or be sued. She could not keep her own wages if she worked. Everything she possessed before marriage became her husband's property automatically. Everything she earned during marriage belonged to him as well. One Kansas territorial statute explicitly stated that a married woman shall have no legal existence separate from her husband in matters of property, commerce, or law. This meant that if a woman inherited land from her family, her husband could sell it without her consent. If she earned money through labor, her husband could take it. If she wanted to leave an abusive marriage, she would leave with nothing, because legally she owned nothing. There are documented cases of women who built successful businesses on the frontier, only to have their husbands sell the entire operation and keep the proceeds. The women had no legal recourse. One Colorado woman reportedly ran a profitable boarding house for 7 years. When her husband decided to move to California, he sold the building, the furniture, and all the supplies. Then left without her, she could do nothing. The courts upheld the sale. The property had never been hers. It had always been his. Coverture laws were not unique to the frontier. They existed throughout America, but on the frontier, where courts were distant and enforcement was inconsistent, these laws were applied with particular harshness. It would take decades of reform before women gained basic property rights in Western territories. And even then, enforcement was uneven. The legal ghosts of coverture haunted frontier women long after the statutes were officially changed. In the modern world, failing to pay a debt might damage your credit score or result in a lawsuit. In certain frontier mining towns, it could cost you your life. Several mining camps in California and Nevada operated under what were called miners' courts, informal legal bodies that made and enforced their own rules without any connection to territorial or federal law. These courts had the power to execute debtors. The reasoning was straightforward, if brutal. In a mining camp, resources were scarce. A man who borrowed money, supplies, or equipment and then refused to pay was seen as a threat to the entire community. He was consuming resources that others needed to survive. One Nevada mining camp statute from the early Rush period stated that any person who willfully and persistently refused to honor a debt of more than $50 could be sentenced to death by hanging. The word willfully was key. If a debtor could prove he was genuinely unable to pay, he might be given extra time or allowed to work off the debt. But if the miners' court determined he was simply refusing, hoarding gold dust while claiming poverty, for example, the sentence was death. There are documented cases of men being hanged for debts as small as $75. One 49er in the California gold fields borrowed $80 worth of supplies on credit, promising to repay after his first successful find. When he struck a modest amount of gold but failed to repay, claiming he needed the money for winter supplies, the miners' court ruled he was acting in bad faith. He was hanged the following morning. His gold was distributed among his creditors. His body was buried in an unmarked grave outside camp. These executions were not considered murder. They were considered justice. The miners' courts operated for years before territorial governments established enough presence to shut them down. By then, dozens of men had been legally executed for financial disputes. Their deaths were recorded simply as sentence carried out. Today, sending a 7-year-old into an underground mine would result in immediate criminal charges. In the Old West, it was not only legal, it was economically essential. Territorial mining laws in Nevada, Colorado, and Montana contain no minimum age requirements for mine workers. A child could legally be employed underground as soon as he was physically capable of performing useful work. And useful work was defined broadly. Children as young as 6 were employed as breaker boys, sorting coal and or by hand. Children slightly older were sent into the narrowest mine shafts, where adult bodies cannot fit, to extract or from passages too small and too dangerous for grown men. These children worked 12-hour shifts in complete darkness, breathing air thick with dust and toxic fumes. They earned a fraction of adult wages, sometimes as little as 25 cents per day. One Nevada mining company's payroll records from the 1870s list 17 workers under the age of 10. The records note their positions as shaft runners and or draggers. None of these children appear in subsequent payroll records. Whether they quit, moved away, or died underground is not recorded. The laws did not require such documentation. Mining companies were not obligated to report injuries or deaths among child workers. They were not required to provide safety equipment or medical care. They were not even required to notify parents if a child was killed in a collapse. One Colorado mine superintendent's journal contains a single entry regarding a cave-in that trapped 4 workers, lost 3 men and a boy. Shaft sealed. Work resumed Wednesday. No names, no ages, no mention of notification or compensation. The boy was listed as an expense, not a casualty. Child labor laws would eventually reach the frontier, but not until decades after the worst abuses had occurred. By then, generations of children had lived and died underground, their names recorded only in payroll ledgers that classified them as something less than fully human. The 13th Amendment abolished slavery in the United States in 1865, but in certain Western territories, forms of legal bondage continued for decades afterward. The mechanism was debt peonage, a system in which workers could be legally bound to employers until they repaid debts that were designed to be impossible to repay. Here's how it worked. A worker would be hired and provided with housing, food, and supplies, all on credit. The prices charged were grossly inflated, often 2 or 3 times the market rate. The worker's wages were set low enough that he could never earn enough to pay off the debt. If the worker tried to leave, he could be arrested for theft. Because he still owed money to his employer, he could be jailed, returned to the employer, and forced to work until the debt was paid. But the debt was never paid. It only grew. One New Mexico territorial statute explicitly authorized employers to use reasonable force to prevent indebted workers from leaving. Another statute criminalized enticement, the act of offering employment to a worker who owed money to another employer. These laws were used primarily against Mexican, Chinese, and Native American workers, but they applied to anyone who fell into the debt trap. One documented case involved a Chinese railroad worker who was recruited to work in a Nevada mining operation. He was charged for his passage, his tools, his food, and his lodging. Within 6 months, he owed more than he could earn in 5 years. He worked in that mine for 11 years before escaping during a fire. When he was recaptured 3 months later, he was returned to the mine owner and forced to work an additional 2 years as punishment for theft of services. The 13th Amendment prohibited slavery, except as a punishment for crime. The frontier found ways to make debtors into criminals, and criminals into slaves. Modern laws establish minimum ages for marriage, typically 18 or 16 with parental consent. On the frontier, no such minimums existed. Territorial statutes in multiple Western regions contain no age restrictions whatsoever for marriage. If parents consented, or if a judge could be convinced to approve, children of any age could legally marry, and they did. Court records from the Arizona Territory document marriages involving girls as young as 12. Records from Texas and New Mexico show similar patterns. In most cases, these marriages were arranged by families for economic reasons. A daughter was a burden, another mouth to feed. A husband meant one less person consuming family resources, and potentially a payment or exchange of property. One documented case from the New Mexico Territory involves a girl married at age 11 to a man in his 40s. The groom paid her father the equivalent of 3 months' wages in exchange for marriage. The marriage was performed by a territorial judge and recorded in official court documents. There is no record of anyone questioning the arrangement. These marriages were not considered unusual. They were considered practical. Girls were expected to begin adult responsibilities as soon as they were physically capable. The law reflected this expectation. It would take decades of reform and considerable pressure from Eastern women's organizations before minimum marriage ages were established in Western territories. Even then, exceptions and loopholes remained common. Some of these marriages produced children before the brides themselves had reached puberty. The records are incomplete. The full scope of the practice may never be known, but the legal framework that permitted it is documented beyond question. This law is difficult to discuss. It is also impossible to ignore. In certain California counties during the early territorial period, statutes were enacted that effectively classified Native Americans as wildlife, subject to hunting, capture, and extermination without legal consequence. The The language varied from county to county, but the effect was consistent. One county ordinance authorized payments for Indian scalps at a rate comparable to bounties paid for wolf pelts. Another statute declared that any Native American found within county limits without proof of employment by a white citizen could be removed by any means necessary. The word removed was understood to mean killed. These were not vigilante actions operating outside the law. These were laws. County governments allocated funds for the bounties. Local newspapers printed announcements encouraging participation. Territorial officials looked the other way. One documented payment record from a Northern California county shows bounty claims submitted for 47 scalps over a 3-month period. The claimants received a total of over $200, a substantial sum at the time. There is no record of anyone questioning the legitimacy of the claims. There is no record of anyone verifying that the scalps belonged to hostile individuals or combatants. There is only the payment record. These laws were eventually repealed as California moved towards statehood, and Eastern observers began paying attention. But they remained in effect for years, during which countless people were killed under color of law. The exact death toll is unknown. Many victims were never counted. They were not considered people under the law. They were classified as something else entirely. Modern legal systems resolve disputes through evidence, testimony, and judicial reasoning. In certain frontier territories, disputes could be legally resolved through physical violence. The practice was called trial by combat, or dueling settlement, and it was explicitly authorized by territorial statutes in at least 3 western regions. Here's how it worked. If 2 parties had a dispute that could not be resolved through ordinary means, typically property disputes or accusations of dishonor, either party could demand trial by combat. If the other party refused, he was presumed to have admitted guilt or falsehood. If both parties agreed, the combat would proceed under loosely defined rules. The winner of the fight, whether through death, incapacitation, or surrender, was legally considered to have proven his case. The loser, if he survived, was legally considered to have been proven wrong. He lost the dispute automatically. One Montana territorial statute stated that when 2 citizens of good standing cannot resolve a matter of honor through civil means, they may settle the dispute through personal combat, with the survivor being deemed to have spoken truth. The word survivor is significant. Many of these combats ended in death. One documented case from a Montana territory involved a property dispute over mining rights. Both claimants agreed to settle the matter with knives. The combat lasted approximately 4 minutes. One man died from a wound to the neck. The survivor was immediately declared the legal owner of the disputed claim. The dead man's family had no recourse. The judge who oversaw the arrangement reportedly said, "The matter is settled. God has spoken." Trial by combat was eventually abolished throughout the territories as more formal legal systems were established. But for a period of years, violence was not merely tolerated by the legal system. It was the legal system. This law emerged later in the frontier period, as Western territories began developing more sophisticated governmental structures. Several Western states and territories enacted statutes permitting the forced sterilization of individuals deemed unfit for reproduction. The criteria for unfitness were vague and subjective, typically including mental illness, physical disability, criminal history, or simply poverty. The procedures were performed without consent, often without notification, and sometimes without the victim even understanding what had been done to them. One California statute authorized the sterilization of any person in a state institution who was judged by administrators to be likely to produce offspring with hereditary tendencies toward crime, insanity, or dependency. The administrators were not required to be medical professionals. They were not required to provide evidence. They simply had to make a judgment. Thousands of people were sterilized under these laws. One documented case involves a young woman committed to a California state institution after being convicted of petty theft. She was 18 years old. She had no history of mental illness. She was sterilized without her knowledge during what she was told was a routine medical examination. She did not learn what had been done to her until years later, when she married and could not conceive children. There was no legal recourse. The procedure had been authorized by statute. These sterilization laws remained in effect in some Western states until the 1970s. Thousands of people were affected. Many never learned why they could not have children. The last known forced sterilization under these statutes occurred within living memory. The 13th Amendment contains a clause that is often overlooked. It abolished slavery, except as a punishment for crime. Western territories exploited this exception ruthlessly. Prisoners in territorial jails could be, and were, leased to private companies as forced laborers. The companies paid the territory a fee. The prisoners received nothing. They worked under armed guard, often in conditions worse than the mines that killed free workers. One Arizona territorial statute authorized the leasing of any and all prisoners to mining operations, railroad companies, or agricultural enterprises at rates determined by the territorial governor. The prisoners had no say in the matter. They could not refuse work. They could not negotiate conditions. They could not complain about abuse. If they tried to escape, their sentences were extended. If they were injured, they received minimal medical care. If they died, their deaths were recorded as natural causes regardless of the actual circumstances. One documented case involves a man sentenced to 6 months for public drunkenness. He was leased to a mining company and forced to work underground. 3 months into his sentence, he was killed in a cave-in. His death was recorded as heart failure. His family was not notified. The convict leasing system generated substantial revenue for territorial governments. It also provided cheap labor to industries that could not attract free workers to dangerous jobs. The system continued well into the 20th century in some areas. Its effects, the exploitation of prisoners, the corruption of justice, the reduction of human beings to economic units, echoed for generations. The 13th Amendment freed the slaves, but it left the door open, and the frontier walked right through it. Modern criminal justice focuses on imprisonment, fines, and rehabilitation. The frontier had a simpler solution for unwanted individuals: exile. Multiple territorial statutes authorized judges to banish convicted criminals or simply undesirable persons from their jurisdictions. The banished individual was given a fixed period of time to leave, typically 24 to 72 hours. If they returned, they could be legally killed. One Nevada statute stated that any banished person found within territorial limits after the expiration of their departure deadline shall be subject to immediate execution by any citizen. Not arrest, not imprisonment, execution, and not by officials, by any citizen. The banishment power was used broadly. Criminals were banished, certainly, but so were political opponents, business rivals, romantic competitors, and anyone who had offended the wrong people. One documented case from a Wyoming cattle town involves a shopkeeper who was banished after a dispute with a local rancher. The shopkeeper had committed no crime. He had simply refused to extend credit to the rancher's employees. A sympathetic judge issued a banishment order. The shopkeeper was given 48 hours to leave. He left behind his store, his inventory, and his savings. He never returned. There is no record of what happened to him afterward. Banishment was often a death sentence by other means. A banished person could not collect debts owed to them. They could not sell property at fair value. They could not return for family members or possessions. They simply vanished from the community, erased by legal decree. Modern courts do not sentence people to physical torture for minor crimes. Frontier courts did. Multiple territorial statutes authorize whipping, branding, and other forms of corporal punishment for offenses as minor as public drunkenness, profanity, or vagrancy. One Texas territorial statute authorized not more than 39 lashes for any person convicted of using profane or obscene language in the presence of women or children. 39 lashes could permanently scar. 39 lashes could cripple. 39 lashes, improperly administered, could kill. For cursing, branding was also authorized in several territories. Convicted thieves could be branded on the hand or face with a letter indicating their crime. The brand was permanent, a visible mark that followed them for the rest of their lives. One Colorado mining camp statute authorized branding with the letter T for theft, L for lying under oath, and M for murder. The murder brand seems redundant. Murderers were usually hanged. But in cases where execution was not imposed, the brand served as a warning. One documented case involves a man branded on the forehead with the letter T for stealing a mule. He spent the remaining 20 years of his life with that mark visible to everyone he met. He could never escape his past. The law had written it on his face. Corporal punishment statutes were eventually repealed as territories became states and Eastern legal standards were imposed. But for years, physical torture was a normal part of frontier justice. The whipping posts have been removed. The scars remain. Orphaned children on the frontier face a legal system that treated them as resources to be allocated rather than people to be protected. Multiple territorial statutes authorize the binding of orphaned or abandoned children to employers as indentured servants. The children had no say in the arrangement. They could be bound until age 18, 21, or even longer in some cases. The employers were required to provide food, shelter, and basic clothing. They were not required to provide education, wages, or humane treatment. One California statute authorized the indenture of any minor child without parent or guardian to any adult citizen who agreed to provide basic maintenance. The child could be required to work from dawn to dusk. The child could be physically punished for disobedience. The child could not leave. If the child ran away, they could be captured and returned. If they ran away repeatedly, their term of indenture could be extended. One documented case involved an 8-year-old boy whose parents died of cholera. He was bound to a rancher who used him as unpaid labor for 11 years. When he finally reached the age specified in his indenture contract, he owned nothing, no money, no property, no education. He had worked for more than a decade and received nothing but food and a place to sleep. The rancher had broken no laws. The arrangement was explicitly authorized by statute. Similar indenture systems existed throughout the territories. Thousands of children were legally bound to employers who exploited them for years. The children had no voice. The law had not given them one. Due process, the requirement that accused persons receive a fair trial before punishment, is fundamental to modern law. On the frontier, certain crimes were exempt from this requirement. Several territorial statutes authorize immediate execution for specific offenses, without trial, without representation, and without appeal. The most common exemptions were for horse theft, cattle rustling, and claim jumping. One Montana statute stated that any person caught in the act of cattle rustling could be summarily executed by the aggrieved party or any witness. No trial, no jury, no judge, just execution. The phrase caught in the act was interpreted broadly. It could mean caught with stolen cattle. It could mean caught near stolen cattle. It could mean identified by accusation from someone who claimed to have witnessed the act. The burden of proof was effectively non-existent. One documented case involves a man executed for cattle rustling based solely on the accusation of a rival rancher. There were no other witnesses. There was no evidence beyond the accuser's word. The accused man was hanged from the nearest tree. His body was left as a warning to others. The rancher who made the accusation later claimed the dead man's water rights. There is no evidence that anyone questioned this convenient outcome. Summary execution laws were eventually abolished as formal legal systems developed, but for years, accusation and execution could happen within the same hour. The rope was faster than the law, and the law permitted it. The final law is perhaps the most disturbing because of how recently it operated and how many people affected. Throughout the frontier period and well into the 20th century, labor contractors recruited workers from China, Mexico, and other countries under contracts that amounted to human trafficking. Here's how the system worked. Workers were recruited with promises of good wages and fair treatment. They signed contracts they often could not read, written in English by lawyers who represented only the employer's interests. The contracts bound them to specific employers for specific periods, typically 3 to 7 years. They could not quit. They could not negotiate. They could not complain to authorities who might help them. If they broke the contract, they could be arrested, imprisoned, and returned to the employer. Their wages could be garnished. Their families back home could be held responsible for their debts. One California statute explicitly authorized the arrest and return of any contract laborer who absented himself from his place of employment without permission. The laborer was not entitled to a hearing. He was simply returned. And the work continued. Thousands of Chinese workers were recruited under these contracts to build the Transcontinental Railroad. They worked in conditions that kill hundreds. They received wages far below what white workers earned for similar labor. They could not leave. When the railroad was completed, many found themselves still bound by contracts. They were transferred to mines, farms, and factories where the exploitation continued. The contracts were illegal. The courts enforced them. The workers had no recourse. This was not slavery in name. It was slavery in effect, and it operated under color of law. The 15 laws you just heard about share a common thread. They were all legal. They were written by legislators, approved by governors, enforced by sheriffs, and upheld by judges. They operated in the open, documented in statutes and court records that still exist today. And every single one of them would be considered a crime in the modern world. The Old West was not lawless. That's the myth. The reality is more disturbing. The Old West was full of laws. It simply had different laws. Laws that reflected different values. Laws that treated human beings as property, as resources, as problems to be solved rather than people to be protected. We like to believe that law and justice are the same thing. That legal means right. The frontier proves otherwise. Law is simply power written down. It reflects whoever hold that power and what they want to achieve. On the frontier, power was held by mine owners, ranchers, railroad companies, and territorial officials who served their interests. The laws reflected that reality. When we study these laws today, we're not studying ancient history. We're studying the foundations of systems that still exist in modified forms. The exemption for prison labor in the 13th Amendment still operates. The exploitation of contract workers still occurs. The tendency to use law as a weapon against the powerless still manifests in ways we are often reluctant to see. The frontier is closed, but its legal legacy remains. The question worth asking is simple. Which of our current laws will future generations look back on with the same horror we feel when reading about frontier justice? Which legal practices that we consider normal today will someday be recognized as the same kind of institutionalized cruelty that defined the Old West? The answer is not comfortable, but the question is worth asking. If you found this exploration of frontier law valuable, consider returning for the next video. There are more hidden chapters of history waiting to be uncovered, more laws that were buried, more truths that were erased, and more lessons that we have not yet learned. The past is not as distant as we like to believe, and understanding it is a first step toward ensuring we do not repeat it.